But we're taking another perspective on the matter, and Mr. Ahmed Raji, a senior advocate of Nigeria, joins us to shed a bit more light on this issue. You're welcome to Sunrise Daily.
Thank you, madam.
Well, there have been insinuations that this appeal court judgment on the case against Justice Nganjiwa is an attempt to shield judges from prosecution. Do you read it like that way?
I beg to disagree. A careful reading of the judgment will reveal that all the Court of Appeal has said is that, look, you need to follow due process. And that the NJC, when there's a complaint against a judge for breach of code of conduct or judicial code, and the same breach also amounts to a crime, that the NJC must be allowed to look into the matter first, take a decision before any other agency, be it EFCC, ICPC, police, or SSS, can do anything on the matter.
Is it a process you agree with?
Very, very agree.
So why do you think it's raised a lot of dust then?
Because it's been misunderstood. The thinking is, oh, judges cannot be prosecuted. Judges cannot be prosecuted, or serving judges cannot be prosecuted. That is not what the judgment says. The judgment is about due process and separation of powers. And the categories of offenses that are covered are limited to what is contained in the third schedule of the Constitution. For example, on page 19 of the judgment, which I will read out now, Her Lordship, Justice Obaseki Adejimo, said, it must be expressly stated that if a judicial officer commits theft, fraud, murder or manslaughter, arson, or the likes, which are crimes committed outside the scope of the performance of his official functions, he may be arrested, interrogated, and prosecuted accordingly by the state directly, without recourse to the NJC. It does mean that it's only in respect of cases such as official corruption, bribe, that relate to his official function, that he or she must have to be reinforced before the NJC, before any of the agencies can have a bite at it.
Well, the EFCC says that this has no basis in law. They believe that this ruling has just been given based on the principle of separation of powers.
And it's also backed up by Section 158 of the Constitution, as well as the third schedule, particularly paragraphs 20, 21, 22 to the third schedule to the Constitution, which, I mean, like Section 158 clearly says that NJC shall not be subject to any control as far as discipline of judges is concerned. And to enable NJC perform this role, they must be allowed to do their job first. And this is not limited to judges. We have similar practice in the police force, in the armed forces, and other security agencies. There's what they call orderly room in the police. There's what they call court-martial and orderly room in the army. And until that internal procedure is exhausted, you will never see a uniformed man in the dock, in the high court or magistrate court outside for trial.
Why do you think that it would seem that there was an exception in the cases of the 5 judges, though?
Which of the judges?
You will recall that before now, the DSS had invaded the homes of some judges, over ostensibly corruption charges, and there was a lot of question then as to whether or not the DSS could even be the one prosecuting. There were claims that the EFCC ought to have been the one on that particular matter. But then the NJC did not step in that matter until the prosecution cases had been concluded.
Well, because there was no complaint laid before the NJC. I think what we should emphasize here is what this judgment is teaching us is there ought to be collaboration between EFCC and NJC, between SSS and NJC and all other security agencies. Nothing prevents EFCC or DSS from filing a report or sending report to NJC and say, oh, look, this is what we have about your judge. Can you look into this? Because even if EFCC investigates, DSS investigates,